United States and this honorable court.
Good morning, everyone. Our first case today for argument is Raynard Jackson versus Dane Esser, appeal number 23-1346. Ms. Graff.
Good morning, Your Honors, and may it please the Court. Carla Graff from Deckert LLP on behalf of Appellant Mr. Raynard Jackson. This Court should reverse and remand because the District Court committed errors of law, ignoring binding Seventh Circuit precedent and misapplying well-worn standards. But Mr. Jackson was kept in an observation cell without any running water and provided no liquids for 5 days.
Wait a minute. I'm going to stop you right there, Ms. Graff. You're not arguing to a jury. I read your whole brief regarding that point, regarding the water. And I thought to myself, this man had nothing to drink for 5 days. I read the whole brief, and I thought, boy, that just seems extraordinary to me. And then I opened the red brief, and I saw that is a contested issue. I get it at the district court that they, Mr. Esser said we made a mistake when we made the admission, and the district judge said, you made a mistake, you're stuck with it. You just admitted he didn't have water for 5 days. But they contest that he had nothing to drink, okay? You're not arguing to a jury. You don't have to convince us that he had nothing to drink for 5 days.
Your Honor, with respect to the issue of the admission under Rule 36, we maintain that the District Court made a correct decision for a number of reasons.
It doesn't matter though on appeal. I mean, maybe he did, maybe he didn't. I mean, but I'm saying to tell us that he, as a matter of fact, that he had nothing to drink for 5 days, it would be better to say the parties agreed or the court found this. But to suggest that there's no dispute as to that issue is overstating the issue, I think.
Understood, Your Honor. We, as Your Honor indicates, we maintain that the evidence before the jury and the evidence that Mr. Jackson put forth with related to summary judgment, both on exhaustion and the merits, it indicated that he had received no water. But at bottom, Your Honors, the issues that we need to address here today are the errors of law that the District Court committed. First, the District Court erred when it granted summary judgment with respect to Mr. Jackson's 10 different administrative complaints. Mr. Jackson exhausted all administrative remedies available to him for those 10 complaints, and he put the prison on notice of all claims on which he subsequently raised in his federal lawsuit. Second, the District Court improperly weighed the evidence and overlooked a genuine dispute of material fact as to the issue of deliberate indifference with respect to Nurse Edge. And
Let's
third,
back up for a minute and just talk through the exhaustion issue that you raised.
yes, Your Honor.
And so with there were five, and five.
Yes, Your Honor.
And so what's your position regarding the unanswered grievances and why that was a mistake?
Your Honor, our position is that Mr. Jackson filed 5 additional unprocessed complaints, as you suggest. And under this court's rules with respect to exhaustion, an inmate who is deprived of any opportunity to pursue their complaints is deemed to have exhausted them because the prison has not responded to them and they have no ability to exhaust further. And that is exactly what happened here, Your Honors. Mr. Jackson submitted 5 additional complaints, and before the District Court, he submitted record evidence of those complaints in addition to a declaration in opposition to the defendant's motion for summary judgment, laying out the nature of those complaints and what he did to pursue them. This court has repeatedly held in Piles v. Nobolowski, Roberts
Was a
v.
Pavey
Neal.
hearing required in those circumstances?
An evidentiary hearing is not necessarily required, Your Honor. This court has previously held that a declaration submitted by an inmate attesting under penalty of perjury and based on their personal knowledge that they submitted a complaint that was not responded to or they attempted to pursue a complaint is enough to defeat summary judgment on exhaustion.
Then what's the purpose of Pavey?
I'm sorry, Your Honor, what's the purpose?
What's the purpose of Pavey? Why would a Pavey hearing ever be necessary? If a declaration is sufficient to bypass a Pavey hearing, what's the difference? I mean, why would a Pavey hearing ever be necessary if a inmate said I exhausted and the prison said no, he didn't? Why would we ever require a Pavey hearing?
Your Honor, that would be a matter of discretion for the District Court to determine whether further evidence would be necessary. And in previous cases, a District Court has determined that that is appropriate, but in other cases, a District Court has permitted it to go forward to trial for issues of credibility to be determined by a jury.
I understand your position that the District Court did not need to have a Pavey hearing,
Is there a problem if we agreed with your point that there's an issue about these 5 unprocessed claims with remanding for a PAVI hearing?
Your Honor, no, we would not take issue with that. And that is our position, is that at minimum, this raised a genuine dispute of material fact that required greater evidence and that the court should have given further consideration to. But even on the motion for reconsideration, the court did not give due consideration to the fact that Mr. Jackson filed these 5 other complaints, and there was ample evidence of that, including his declaration that he had exhausted those complaints or attempted to pursue them. But, Your Honors, there were 5 other complaints that Mr. Jackson had filed, and they were processed by the prison, and it is entirely undisputed on appeal that Mr. Jackson exhausted the administrative remedies available and confirmed the same in writing with ICE Ray. And all of those complaints put the prison on notice of the claims in which were subsequently raised in his lawsuit. Specifically, they addressed the conditions of his cell, the deprivation of water, and the deprivation of medical care resulting from the totality of those conditions. And this court has been clear that the purpose of the PLRA is to put the prison on notice of an issue and provide them with an opportunity to correct and investigate that issue. Specifically, the PLRA incorporates the Wisconsin DOC code here. And the DOC code that was in operation at the time only required that an inmate identify the issue that is at issue. And in Schillinger versus Kiley, this court said that that is simply putting the prison on notice of the issue for which redress is sought. And once again, that's exactly what Mr. Jackson did here. And we know that he was successful and that the purpose of the PLRA was achieved because the prison actually implemented a unit-wide policy to avoid the same situation from happening again.
Where do we draw the line? Does that raise a line drawing problem? If you look at Mr. Jackson's first grievance, his grievance was Lieutenant Dane Esser had an obligation to put my water back after he was notified on several occasions to do so. He never identifies any of the other defendants that he later sued. And your argument is that this is enough to put the prison on notice as to these other defendants. But where do we draw the line? Could he sue anybody in the prison that he wanted to that had any, how detailed is it? What does the prison have to do? They have to hire an outside law firm to come in and conduct an investigation to determine who had knowledge or who might have had knowledge of the water issue, and then he can sue anybody at the prison he wanted to?
No, Your Honor, we do not think that it would be that expansive. Once again, turning back to the issue of notice, it's about the prison having opportunity to investigate and correct an issue. And here, we're not saying that Mr. Jackson would be able to name everyone in the prison.
Well, where do you draw the line specifically in this case?
In this case, it would be appropriate to look to the unit, Alpha unit. He was in cell A404. He was in a clear observation cell where he was visited up to 15 times a day. And the prison had the opportunity to look at the log, look at the individuals who were required to visit Mr. Jackson, who were on duty on Alpha Cell. And that is exactly what bears out in the record here. The prison implemented not a prison-wide reform, but a unit-wide reform.
Should we or have we ever required a prisoner to say with specificity in his complaint, this particular officer, in this case, deprived me of water, and others in his unit, or this officer and other officers known and unknown?
No, Your Honor, the court should not require that, nor has it. In both Maddox versus Love and Henry versus Deschler, this court did not require that an inmate put the names of the individuals related to the issue. They found that the fact that, for example, in Henry versus Deschler, the inmate identified the fact that he received the wrong medication and sought redress for it was enough. The prison was then able to investigate the issue and identify those that were involved. The same
What do we
happened-
do with the guidance from, we're familiar with our cases, but there's guidance from the Supreme Court, Jones versus Brock. And in that case, the Supreme Court outlined kind of the guidance for lower courts under the MLRA. And so what's your position regarding this need, as has been kind of suggested, this need to name all the defendants even before discovery? And what type of burden would that put on inmates attempting to file under the PLRA to be able to even exhaust?
Your Honor, I think it's important that acknowledging the Supreme Court's direction that these requirements are to be strictly construed, but yet these are still pro se inmates, and the idea is to gatekeep, but not with extremity. And here, we have to again look to the Wisconsin provisions because the PLRA explicitly incorporates those state codes, and Wisconsin does not demand naming all individuals. It only demands clearly identifying the issue. And where an inmate has clearly identified the issue, and again, the prison has the opportunity to investigate and correct or determine those who might be involved, then that should be enough for an individual to seek redress for their constitutional violations. And looking at an individual like Mr. Jackson, he sought to diligently pursue the grievances here. He filed 10 different complaints. He sought to confirm that they were exhausted for purposes of the PLRA. He intended to bring suit. And it shouldn't be that a prison can implement a unit-wide policy of reform, but that Mr. Jackson shouldn't be able to bring suit on that issue. The district court said that there was no indication that there was a broader reaching issue, but the fact that the prison took reform and implemented a new policy exactly indicating there was a broader issue belies that conclusion.
Does
Should we-
Mr.
I'm sorry, go ahead. Should we move to Nurse Edge?
I'm sorry, Your Honor. could you-
Should we move to Nurse Edge in the time that you have?
Yes, Your Honor. I would be happy to move to Nurse Edge. Now, the district court improperly weighed the evidence as to the summary judgment on Nurse Edge and overlooked a genuine dispute of material fact as to whether she refused Mr. Jackson medical treatment. But it's entirely undisputed that Nurse Edge visited Mr. Jackson on May 27th, and he told her that he had no running water in his cell. He showed her he had no running water in his cell. She informed Lieutenant Esser, and then she did not provide any medical treatment on that
But
day.
isn't that the end of the analysis? You know, she informed Lieutenant Esser the water was turned on. She observed him drinking. Dehydration is treated with fluids. She was not deliberately indifferent, right? The water was turned on. In other words, she treated him.
No, Your Honor. The fact that Nurse Edge was aware that he had no running water for 5 days at that point, as a nurse, as a matter of common sense, it might require additional treatment, and he specifically asked for additional treatment as
And
he
that's
testified.
negligence. How is that not negligence?
Your Honor, that's an issue for the jury to decide.
Wait. An issue for the jury to decide whether it's negligence or whether it's deliberate indifference?
Whether her mental state was sufficient for that. As this court held in Conley versus Birch, White versus Woods, Sherrod versus Lingle, the issue of deliberate indifference and the mental state required under the Eighth Amendment is an issue more appropriately reserved for trial for the jury to be able to hear all of the evidence and testimony and determine whether her conduct amounted to deliberate indifference. And that's exactly the situation we have here. The district court was faced
But
with
the conduct that we have in front of us, what raises it to the level of deliberate indifference
the fact, Your Honor,
for it to survive summary judgment?
Your Honor, it's the fact that Mr. Jackson said he requested medical treatment and he was denied medical treatment.
Ms. Nurse Edge attempted to provide medical treatment, and he refused, is that correct?
Your Honor, that is not the position that Mr. Jackson maintains. He specifically said he did not want treatment for his chest pains, but he requested treatment for his deprivation of water and his dehydration.
Did
And in-
Nurse Edge attempt to provide that treatment?
Mr. Jackson maintains that she did not. While Nurse Edge does, that's exactly the issue of the summary judgment where the district court erred. The district court should not have weighed the competing testimony of these two parties or drawn all inferences against Mr. Jackson as the non-movement. Rather, the district court should have taken Mr. Jackson's testimony as enough to defeat summary judgment. In Payne versus Pauley, this
I
court...
thought he did agree in the record that she attempted to provide medical treatment and he refused the first time.
Again, Your Honor, that's that he refused, that he did not want treatment for chest pains. He
Okay.
specifically wanted treatments for the deprivation of water and the dehydration. And again, that's enough to defeat summary judgment. This court has repeatedly said, for example, in Payne versus Pauley, that an individual's own recollection of the events based on their personal knowledge is enough to defeat summary judgment. We cannot look at it and say that it is self-serving. The fact that one individual has made a claim for or indicated that this is their knowledge of the events, that is enough to defeat summary judgment. And the district court should have seen that as a genuine dispute of material fact as to whether she had the requisite deliberate indifference under the Eighth Amendment. And therefore, this case should have gone to trial on the issue of summary judgment and the merits of whether Nurse Edge acted with deliberate indifference. Your Honors, and I see I have 2 minutes left, and I would just like to turn briefly to the issues of the motions in limine. The district court erred in ruling in favor of Esser on 3 different motions in limine, and in doing so, it applied abrogated standards related to character evidence that ultimately prejudiced Mr. Jackson's case before the jury.
Can we just focus on the hunger strikes?
Yes, Your Honor. As to the hunger strikes, first and foremost, the district court committed an error of law, and a per se error of law warrants reversal on abuse of discretion. The district court did not apply the evidence of the hunger strike for any purpose other than the most forbidden inference under Rule 404B. It said it was admitting that evidence for the purpose of showing that Mr. Jackson was, quote, a very difficult inmate to control and fights back. That is, by its very definition, character evidence and a propensity to act in accordance with that character. Doing so was exceptionally prejudicial to Mr. Jackson's case because it permitted the jury to infer that he might have refused water or chose to forgo water even though it was admitted at the time at trial and before the district court judge that Mr. Jackson had no access to water. And once again, this was an error of law and a blatant application of Rule 404B that was improper. As to the other motions in limine, however, Your Honor, the district court committed other errors of law. And again, these are per se abuses of discretion or that warrant reversal. As to Lindsay, the court applied the incorrect four-part test that this court has since reversed in United States versus Gomez, and it rigidly applied that test to the detriment of Mr. Jackson's case.
How would Lindsay have helped Mr. Jackson? Lindsay Esser was found not to have acted deliberately indifferent.
Your Honor, I see I'm about to expire my time, but if I may respond to your question. So with respect to Lindsay, even though the district court in that case there was no finding of liability, that's still probative evidence of the fact that there was a lawsuit raised against the same defendant involving the same exact conduct. That would show absence of mistake or knowledge of a particular issue. But the district court, in applying that abrogated test under Zapata rather than Gomez, rigidly adhered to the requirements of similarity, which this court has said is not a strong indication of relevance under Rule 404B. Your Honors, my time has expired. For the reasons set forth in our briefs, we respectfully request that this court reverse and remand and issue a new trial on all claims. Thank you.
Okay, thank you, Ms. Graff. Mr. Murphy.
Good morning, Your Honors. My name is Mike Murphy. I represent the defendants' appellees in this case, which is an appeal from a jury trial where the plaintiff was represented by counsel. I feel like it might be most helpful to go straight to exhaustion, if that's okay. There's no record-based argument of 10 complaints here. There's just not. When I went to the reply, on page 4 of the reply, there's a bullet point list of 5 and then 5, which when I flipped to that page, I thought for a moment was pretty compelling. Look at the record sites for that. The first 5 cite to the plaintiff's exhibits showing the 5 inmate complaints that were filed. The second is to the plaintiff's...
I think my concern is more so with the responses from Ms. Ray. And at the top of one of those responses in June, I think it's June 4th, where Mr. Jackson says or writes at the top of the grievance, confusing, stop confiscating my 5 complaints.
Yeah, I really like to address that. So the idea of compensation came up below when the plaintiff was contesting dismissal for exhaustion. It's records numbers 46 and 47. Jackson believed that there was a requirement that he get a response, like a receipt and affirmation, within 5 business days. I don't think that's the requirement. That's not an issue here. But when 5 days passed after he submitted his 5 complaints and he hadn't heard back, he started saying, "You've confiscated my 5 complaints. Stop confiscating them. You have to process them." They weren't confiscated. They just weren't processed yet. But those are the 5. Those are the same 5 that the defendant submitted into the record. They're the same 5 that Mr. Jackson referenced in his affidavits. And
Mr. Murphy, though, you're making arguments that may be compelling, but are you arguing to the correct court? You know, and the way I read the summary judgment orders here, it seems to me that the district judge granted summary judgment, and then Mr. Jackson, proceeding pro se, filed a motion for reconsideration with the district court and said, "Judge, you misunderstood my argument and my declaration. I'm not complaining about 5 grievances. I'm complaining about 10. Yeah. And then in one page in the order denying reconsideration, the judge addresses those other 5 and says it's frivolous and cites some reasons for which they're frivolous. But when I look at the record, the reasoning does not necessarily track the record as to why those 5 unfiled or unprocessed grievance, whatever they are, it just seems like you're asking us to make evidentiary determinations that would be better served by having the district court determine at a PAVI hearing whether or not there were 5 grievances or 10 grievances. And Mr. Jackson can testify and Ms. Ray can testify, and the judge can make credibility determinations, and then that's the end of it or not. But let me ask you a question. If it goes back for a PAVI hearing and the judge determines that those claims were processed, does Mr. Jackson have a estoppel issue or problem on the water claim and the singling out claim? In other words, there's already been a trial on those claims.
that's right.
And the jury found for the defendant. should there be another trial against additional defendants, at least when Mr. Jackson's theory seemed to be it was Dane Esser that committed the constitutional violation. Others may have been aware of it, and it was, I think he said in his closing argument, it may have been negligence on their part, but it didn't amount to a constitutional violation. Isn't that the end of it, end of the matter as to those defendants on the water claim and the 14th Amendment claim?
Yeah, yes. I think two points to make there. For one, it is important when thinking about exhaustion and what was said or not, that this matter went to a jury trial. That this was not those core issues. The core issue here about was water on or off, when it was on or off, who knew, who turned it on or didn't turn it back on, was decided by a jury trial, and that doesn't need to be decided again.
I thought the jury decided whether or not Esser turned the water off or not. Did it make the determination that the water in the observation cell was not on or not off?
That it was not off. No, it did not. I think the arguments made to the jury were pretty broad. I think the question there was whether Esser was deliberately indifferent. And, it was a 3-day trial, so things were brought up about it being shut off, things were brought up about when it was turned back on and what happened when it was turned on. But the finding there was that Esser was not deliberately indifferent with regard to those theories. With regard to exhaustion, I don't think the record, including the motion for reconsideration, has enough in it to warrant an evidentiary hearing. I think the judge was right. I don't think that at any point Jackson articulates
Is that our standard though? He has submitted a declaration where he says, "I submitted these grievances. They're missing. They haven't been processed," and we've said the exact opposite of what the district court said, which is the content, whether there's any evidence in the record of the content, all of that's irrelevant. If there's a question about whether there's been exhaustion, the judge should look into it and have an evidentiary hearing.
Yeah. So I don't think the record reflects an argument at that stage, going back in time to what the district court had in front of it, not what has been argued very compellingly here. I don't think there was an argument of 10. I don't think there was. I think the district court was looking at an argument of 5. He said that the 5 were confiscated. They were not processed.
But what do you make of Mr. Jackson's declaration? This was the declaration in support of his opposition to the defendant's motion for summary judgment.
I don't believe he identifies 10. If I'm thinking the right place, I can picture this page of his declaration where at the bottom of a page he lists, I've got these inmate complaints, and he's got the numbers, and 4 of them match the 5 that are in the defendant's evidence. Then starting on the next page, he begins to describe them, and he describes 5, and they're the same 5. I don't think that there was anything that the district court was working with to say, we have a dispute that 10 was filed. I think that what was going on in district court was there were 5 filed. Were they broad enough to exhaust all the claims, yes or no? Were they properly processed? Were they confiscated? Were they administratively exhausted how they should have been? And Jackson said they were not. They ultimately were. The defendants have said they were all administratively exhausted. All I can say is I've read those pages a number of times, and going back in time, looking what the district court had in front of him, I don't think that there was a dispute that warranted a hearing at that point. I can move on to Edge, if that would be helpful. On Edge, I think where the difference in reading the briefs, I think where the difference lies is the plaintiff is saying on appeal that there was a dispute of fact, that there are different stories as to what happened at his cell front on that date.
So
And that is true.
Can we go back for a moment
Sure.
as to what the district judge was on notice? I pulled up the response that Mr. Jackson filed in regards to the exhaustion issue, and items 1, 2, and 3. Jackson lays out that the feces being smeared,
Yeah.
the chemical agents at item 2, and he goes through, these are my other 5 grievances, which the prison did not answer. And he does that on page 3 and 4.
Yeah. So happy to address that, because that is argument about how much the 5 that he filed did capture. And that point in particular, so the first one that he filed, I've got it at 43-2 of the record. has got on top a brief summary, and it says Captain Brown erroneously utilized chemical agents on, and then it's redacted, but the person who was in the cell prior, who was contraindicated. So there's a complaint there about chemical agents being utilized on that other person who Jackson says was contraindicated. Then he goes on to his issue. So what that briefing back and forth about, was that enough to preserve his claim of chemical agents in the cell? I don't think he's talking about a different one.
I don't know, because if we look at his brief that was filed, he provides a heading, and he says, these are the submissions of grievances regarding the following. And then in the portion that I'm trying to direct you to, in his brief, he puts headline D, and he says the following grievances regarding health and personal safety. So I believe what Mr. Jackson is trying to do is to highlight the first 5 would have to, go in line with the 2 per week. The other 5 that I filed involving health and safety under heading D, 1, 2, 3, 4, 5. And so the question being, why would there not have, necessarily have need to been a Pavey hearing here when he outlines the first 5 sets under heading C, and then the new set under heading D?
Yeah, so again, I think I can picture the pages you're talking about. I'm not totally sure, but going back in time to what the district court had then, not what has been developed since, I don't think it even facially describes 10. He says repeatedly in those pages, my 5, the 5 that I filed. And the 5 in those lists where he says my personal safety align to the arguments of the 5 that everyone was looking at, the same 5. So the chemical, just the example that we were going through, him arguing that first one involved, chemical spray, is because he talked about chemical spray against the prior person, and he's saying, well, that's broad enough to apply to me. And the arguments that he makes of those 5 match the 5 that everyone is talking about. I don't think the district court had any reason to think, I don't think there's a reason to think now that we're talking about 10 ever. It's just a characterization of the 5. With regard to Nurse Edge, I think the point has been made in the briefs and this morning that there's a difference. There's a factual dispute about maybe exactly what happened at that cell front. My point is that it's not material, and that Edge was properly dismissed on summary judgment, no matter what version of the facts you're looking at. And where I think the rubber hits the road on that is Jackson's deposition transcript. It's filed at both Record 121 and 162. The relevant section starts at page 26, but I think page 30 is really where the core of it is. And at that point, again, looking at that snapshot in time at summary judgment, the defendant's position was Jackson refused treatment. Edge was there trying to treat, and he said, get away from me. I don't want to be treated. Go away. Jackson's position was that Nurse Edge was there, said he needed to be treated, said he might be dehydrated, said, come over, I need you to be looked at. But Esser refused to allow that to happen, and Esser erroneously said that he had declined medical care. That, I suppose, is a difference, but it's not material as to the dismissal of Nurse Edge. Under either event, she was there, attempting to treat, and was unable to. The dispute there doesn't matter for whether she should be dismissed at summary judgment or not, and she was correctly dismissed.
What if the allegation is, as we heard this morning, not that she wouldn't treat at all, she wouldn't treat for the dehydration?
Yeah. The plaintiff's own testimony on page 30 there just doesn't make that distinction, and that is...
Say it one more time.
The plaintiff's own testimony on page 30 just doesn't make that distinction. And so what the judge had there was, yes, 2 versions. The defendant saying that he affirmatively refused care, Jackson saying that Edge tried to treat him, but Esser prevented it. Neither show any disorder of deliberate indifference by Edge. And so, even though there's a dispute, it wasn't material, and she was correctly dismissed.
Why was it proper for the district court to admit the evidence of the hunger strikes?
The hunger strike was properly admissible for 3 reasons. First, that Nurse Edge personally had observed Jackson at a time when he hadn't been eating. So when she examined him from the cell front the best she could, she had a really good basis to know whether he's experiencing a medical emergency or not. Second, there are protocols in
Wouldn't
place.
she have that just based on her knowledge as a nurse, without regard to whether she saw him before, not eating or not drinking?
Her
Is
general.
that,
Sorry,
is
sorry.
that testimony necessary for that proposition?
The point that you just made could have been made without that. It is stronger with that, and that made it material and relevant and admissible.
Okay, you can move on to the second reason.
Second reason is that there are protocols in place that the prison and medical staff takes, including for Jackson in the past, when he's not eating or drinking, and it is evidence of how they would have acted if they had known this.
Couldn't they have testified about the protocols independently?
Yes.
Without the, okay. And so can you just get straight to the reason that the district court gave for admitting the evidence?
Yeah, so the district court talked about this as part of the tableau of things that were relevant in the case, including Jackson's past efforts and methods of manipulating staff. And he made one phrase in passing during a pretrial conference that has been, really highlighted by the appellants, and I understand why. But that was not in front of the jury. It was not the reason for which the evidence was used in front of the jury. I do think it was a sound reason anyway. That soundbite that has been pulled out of those pretrial transcripts was not in front of the jury, and really this evidence was highly limited at the jury.
My
before the
question,
jury.
I guess, was that soundbite using your words appropriate after Gomez?
It was not reversible error. It is maybe not how it could have been stated. It was not reversible error. That's my position on that. I see that my time is up. We respectfully request that the decision of the jury trial be affirmed. Thank you.
Okay, thank you, counsel. The case will be taken under advisement. Our case number 2 is Vega and Ramos versus Chicago Board of Education, appeal number 231183. Just 1 minute. Okay, Ms. Shaw, whenever you're ready.
Good morning, Your Honors. May it please the court. My name is Ann Shaw on behalf of the appellants and the Plaintiffs' Counsel. We seek the vacating of 2 orders entering sanctions and monetary sanctions against Plaintiffs' Counsel. The threshold issue in this case is whether plaintiffs' due process rights were honored in the sanctions that were entered by the court. And the Supreme Court in Chambers versus NASCO and Roadway Express both hold that due process requires that the attorney being sanctioned be given notice and an opportunity to respond. The Seventh Circuit has gone into more clarity under both Larson as well as Johnson v. Cherry and stated that the notice has to be explicit, alert the specific attorney of the conduct that they may be sanctioned for, and give them the opportunity to respond to that specific conduct. And in this case, there's nothing in the record, neither on the July 20th, 2017 hearing, nor on the September 11th, 2017 hearing, or even the actual evidentiary hearings in October 30th, 2017, and November 27th, 2017, where the court or defendant's counsel sought sanctions. It is understood that the court on its own, sua sponte, can enter sanctions, as well as an attorney being notified by a motion for sanctions against them, but this was not the case. In fact, every single record indicates that all the parties were operating on plaintiff's motion for sanctions against the defendants for discovery violations.
Plaintiff's motion for sanctions is July 19th, 2017.
Right.
The very next day at a hearing, the district court says, I'm going to schedule a hearing. He holds an initial hearing to get clarity on the alleged assault. And that's the first of a couple comments the district court makes about getting to the bottom of what happened with the assault. What's your position on why that's not notice that the court is looking at an alleged assault,
So
which
Your-
would raise the specter of some sort of penalty for that?
So, Your Honor, this court in Johnson v. Cherry already determined that that isn't sufficient notice. The notice has to specifically name the attorney as well as what conduct he or she may be sanctioned for. In fact, in Johnson v. Cherry, the attorney that was sanctioned, actually, there were several things in that record. One, the court in Johnson v. Cherry, the district court in Johnson v. Cherry, actually gave a general admonishment to all the parties that somebody could be sanctioned for it, and wanted to do his own hearing sua sponte to get to the bottom of who may have or may not have allegedly forged the attorney's signature on a filing. The next thing was the attorney that was sanctioned also was able to participate in the hearing, the evidentiary hearing on the matter. And third, the sanctioned attorney also was able to file her own memoranda in defense of her position. Even under those circumstances, this court found that that wasn't sufficient notice because the attorney who was being sanctioned could not appreciate that she could be sanctioned since it was on her motion to strike, and it was.
Is there a difference with Johnson? Because in that case, it was an open question. Who signed this document? Nobody knew. That was the big mystery. In this particular case, there were only two actors involved in this alleged assault. It's allegedly Ms. Shaw and then Ms. Dreisenmeyer. Dreisenmeyer was the alleged victim. So there wasn't this open question of who are we talking about here. And then as for the opportunity to respond, here, once it does become available, there are several instances when Ms. Karen Shaw, does not respond to the issue of sanctions once it is raised. So how do we take that into account, or should we?
So, Your Honor, there is no case law that allows for what we could characterize as constructive notice when it comes to attorney discipline.
But isn't
and
it true, though, that
sanctions.
notice of potential sanctions can come from opposing counsel?
Yes, but that did not occur under the due process requirements of both Johnson, Larson, which is this court's cases, as well as Supreme Court cases, Roadway and Chambers. All these cases suggest, and actually Larson and Johnson v. Cherry specifically state that notice must be given before any hearing is done. The first time that defendants raised the issue of seeking sanctions against Ms. Shaw was in their post-evidentiary hearing. And the court erroneously and abused this discretion by saying that was correct notice because it gave her a few days, which that is not the purpose of a post-evidentiary brief, excuse me. And in this matter, to address Judge Jackson's question, there was a dispute. In Johnson v. Cherry, there was also a dispute as who signed this. But in our case, the dispute was whether this was an inadvertent touching. And in fact, on September 11, 2017, the court actually admonished Ms. Dreschmeyer directly because she asked that at worst she's a victim of an inadvertent touching. And the court admonished her directly and stated that if your reaction was so outrageous, you could be at fault. So that all the indications, all the proper notice was only given to defendants, counsel, and Ms. Dreschmeyer, both by the court as well as in plaintiff's motion for sanctions.
Ms. Shaw, can I ask you a question regarding the Johnson case? In Johnson, what happened in Johnson is distinguishable here. In Johnson, we held regarding the sanctions and notice. There, though, the judge sanctioned counsel at the end of the hearing, right? That's different. I mean, here you had a hearing, and then at least is it Karen Shaw? Karen Shaw was on notice when the brief was filed that the state was seeking sanctions against her, the city was seeking sanctions against her. Right? I mean, so Johnson is distinguishable because there was no post-hearing briefing. Here there was.
Judge, so to answer your question, it's not distinguishable, right?
Why?
So-
Address why, because the issue is one of notice. You need to have an opportunity to respond. And here, you have the opportunity to respond.
So the due process requires, I mean, this has been determined by the Supreme Court and this court, due process requires that notice be given before any hearing on the matter, and also directly to the attorney as to what conduct that attorney might be sanctioned for. There is no case law cited by the defendant or the court that suggests that due process is satisfied by giving notice after the evidentiary hearing has been conducted.
Let me ask it this way. Ms. Shaw came to the hearing with an attorney. What do we make of that fact? And by the time she comes to the hearing, she's aware that there has been an ARDC complaint filed. And so if we pair that with Judge Pryor's mention of our law that opposing counsel can provide notice, how do we conceive of what Karen Shaw knew at that moment, the moment she walks into the evidentiary hearing, knowing there's been an ARDC complaint filed and having an attorney?
So, Your Honor, your question touches upon a number of issues here, right? So the defendants could have filed a motion for sanction or sought sanctions directly against Ms. Karen Shaw for the alleged events. However, they chose to proceed with the ARDC and also file a criminal case. And that actually triggered younger concerns, right? Because there's a parallel state court proceeding, and this court has recognized that state disciplinary proceedings are a important state interest, and those proceedings are covered. And so the court should have made, and actually the court does talk about it numerous times, but the court should have actually made a determination.
You're skipping to your younger argument, which I am interested in. But what's the answer to my question about whether at that moment we should conceive or not that she has notice from opposing counsel that the alleged assault is something that the court could penalize?
Again, Your Honor, that would be what would be characterized as basically constructive notice, right? I mean, the reason why in Johnson the court said that it needs to be explicit and name the attorney either by the court or by the defense counsel is because it gives, it provides notice that...
Maybe let me try to ask the question a different way. Did anyone else, other than Ms. Karen Shaw, did anyone else bring counsel to this evidentiary hearing?
Yes.
And so who else brought counsel to represent themselves at the evidentiary hearing?
Ms. Dreschmeyer.
Oh, right. So any other plaintiff's counsel, did they bring counsel to represent themselves?
No.
All right.
And addressing the counsel argument, this is exactly why the specific notice had to be given. Ms. Shaw did not retain the attorney until the second hearing, which is on November 27th.
When she had notice?
She did not have notice. The reason she did that was because there was pending criminal matters. And so she was concerned that she didn't want to jeopardize at the time that she believed that there was criminal proceedings pending, that she did not want to jeopardize any potential defense that she would have. So she actually hired this attorney who is a criminal defense attorney to help her be able to go through it. And then the reason why he was there and the reason why she didn't testify was because there was no notice to her that she was on, that she could be sanctioned.
So because I don't want to run out of time, in the notice of appeal, we do have to address the jurisdictional question as to whether or not if this is properly before us and who are the appellants. And so can you address that argument?
Yes, Your Honor. So the The orders of March 28th, 2017 and December 28th, 2022, 4 years later, entered monetary sanctions against plaintiff's counsel. And at the time that of the orders being entered, there were more than one plaintiff's counsel. There was myself as well as Attorney Don Villar. And so the rules were amended in 1993 that if there is an order that is on its face that involves attorneys that are part of it, and I would suggest the plaintiff's counsel does actually involve the attorneys of record at the time that orders were entered, that even if their names are not explicitly on the notice, as long as the orders are attached and gives the court instruction as to who has an interest in it, then the court does have a jurisdiction to hear their appeal. And then myself, I actually signed the notice of appeal, and there is a case that suggests that even the attorney signing the notice gives the court the jurisdiction to proceed, that they want to hear it on the merits. And because this is a joint sanctions motion, and there was no notice given to myself or Mr. Villar that there's nothing in the record that says we did anything wrong, we had anything to do with these things, and the court doesn't specifically name us, and the defendants concede that, and there is no case law saying that we should be sanctioned under those circumstances. I think that the court does have jurisdiction, even though we're not specifically named, in the notice of appeal because it's in the orders.
And so, just for clarity, which sanction in the March order are you appealing?
We're appealing all the sanctions. All the sanctions. I mean, it is stated in our brief, maybe not clear enough, but
the reason why I ask is because this is decided in 2018, the disqualification. The monetary sanction is finalized in the December 2022 order, and then the notice of appeal is filed in January of this year. And so, from a timing perspective, did you need to appeal to the disqualification determination, the notice of appeal in August of 2018?
August, or are you talking about?
So on the merits, the motion for summary judgment, and then there's a final judgment entered. There's a notice of appeal filed on the merits. And so from a timing perspective, did you need to wait until the monetary sanction was satisfied before you could file your notice of appeal?
Yes, Your Honor. The March 28, 2018 order was not an order that we could appeal interlocutorily. And also there's case law that says that even if a lawyer is removed from a case, that is not subject to interlocutory appeal. We had no choice but to wait until we had the final order, which unfortunately took 4 years for the judge to issue. We didn't anticipate it would take so long, and the judge did not allow us to come back for any arguments. He just kept moving the status dates on our objections for 4 years.
Thank you.
All right, thank you, Ms. Shaw.
Thank you.
Okay, Mr. Doyle. You may begin wherever you
May it please the court. I'm Thomas Doyle for the Board of Education and the other board defendants in this case. The sentence that rings truest with me is from the March 28th order, where Judge Feinerman says, this is an extraordinarily unfortunate incident. And that's exactly what this is. Now the question, the first piece that the panel was interested in was talking about notice. I'd like to start there if I could. There were indications all along that the judge was trying to figure out what happened and who was at fault. An indication of that, for example.
Let's drill down.
Yes.
Where in the record is Ann Shaw or Don Villar put on notice that they could be sanctioned for their conduct?
The March 28th order says that plaintiff's counsel shall have to pay a monetary sanction in an amount to be determined. it does not identify by name more than that. The same usage is in plaintiff's counsel's briefs when they respond to that, and the same usage is in the December 28th, 2022 order.
Before the sanction, that's the argument before the sanction, where they put, those two put on notice
Oh,
that sanctions are possible.
very good. In our post-hearing brief, we put in a request for sanctions, and that's a January 2019 post-hearing brief. It is very clear when it was, when we filed it. The date on that is, January 19th of 2018. January 24th, the plaintiff's counsel responds by filing their own post-hearing brief. They do not address the issue of sanctions.
On January 18th, you clearly request sanctions against Karen Shaw, but was that it? I think that's the question. Where did you request sanctions against the other lawyers?
Oh, I do not recall, Your Honor, but the
That's
form,
a problem, right?
The form of the sanction, though, relates to what we were asking for. We were asking for a sanction for the attorney's fees that we had been put through. That is more than Karen Shaw's conduct, because it is all of the conduct that followed, all of the motion practice and the hearings and everything else. That's the injury that we were saying should be addressed.
I'm not focused on
Yes.
Karen Shaw. I'm really wanting you to direct me to Ann Shaw, Don Villar. And if I look at the January 19th, 2018 post-hearing brief where you request sanctions, it's against Karen Shaw. Where, anywhere in the record, is there notice for the other two lawyers?
Until prior to the March 28th order, the March 28th order says plaintiff's counsel. I don't believe there is any particular notice that the other two are up before then.
So then are you ready to concede the issue with Ann Shaw and Don Villar? And if not, why not?
Okay, there's two reasons why I'm not. The first is, Your Honor, during the entire district court proceedings, none of the plaintiff's counsel raised this issue. And in fact, they briefed their opposition to sanctions, which is filed at record number 242. It's the June 28th, 2018
But
brief.
isn't just the remedy here just to remand to the district court, and if the district court wants to provide notice to Ann Shaw and Don Villar, he can do it, or she can do it, because Judge Feinerman is gone. I don't know who the district judge will be. They can provide adequate notice under the due process clause, and then they can make a decision as to whether sanctions are warranted.
We could do that. Otherwise, the sanction might be collectible against Karen Shaw only.
Right.
I mean, but at the end of the day, it doesn't matter. The sanction is collectible against somebody. But Your Honor,
Well,
to
it
your
matters
point,
to
though.
Ann Shaw, and it matters to Don Villar.
And it
as well,
matters-
yes.
But if it mattered, they should have raised it in the district court, Judge.
It also matters because our case law requires specific identification of the parties, who might be sanctioned. And we also have this case law. I wanted you to address Johnson, where, in Johnson, there was a hearing, and we said a hearing is not sufficient. Here we have a hearing. It's the hearing.
Well, now the question is on that Johnson question, the Johnson issue. Did anybody have notice? Or is the question, did Ann or Don have notice? They're separate questions, and let me parse that out. Certainly, by the summer of 2018, or by the summer of 2017, Karen Shaw should have recognized that she was facing sanctions.
What do you make of Miss Ann Shaw's argument that constructive notice is not sufficient?
Well, there's actual notice. At the the September 11th, 2017 hearing, the district court judge said, because I am concerned about what happened after this deposition, Karen Shaw and Lisa Dreschmeyer may not participate in any more depositions until I get to the bottom of this. They both clearly understood at that point that the judge was trying to figure out which of them was at fault and which of them was going to face whatever the next piece of the proceedings were. There are then 2 days of evidentiary hearings. The second day of the evidentiary hearing, Karen Shaw shows up with a lawyer. There's a couple of pieces to this as far as Karen Shaw's notice. What would she have done differently? There isn't anything she would have done differently. Had there been a sanctions order at the very beginning that said she is facing sanctions for what it is that she did. She told her story repeatedly in affidavits and in court hearings. She did the opening statement at that 2-day evidentiary hearing, and then they filed multiple briefs after the sanctions were up. There isn't any question that Karen Shaw understood that she was facing sanctions and had an opportunity to respond. And she had multiple opportunities for that. Now, to parse the Johnson question a little closer, as to Don and to Ann, if it were so important to them and they were objecting to the district court's usage of plaintiff's counsel, they should have said something. Because then the district court, to your point, Judge Kirsch, the district court could have done something about it then. The district court could have said, I will fine-tune my order. The district court could have said, I will make specific findings. The district court would have said, I will ask each of them to file their own separate briefs. Whatever it is the district court might have wanted to do to cure whatever the technical defect was in his usage of plaintiff's counsel, he could have done it
But the
had
defect
they
is due
raised it.
process.
But they didn't raise it, Judge. They didn't understand at the time that they had any ambiguity. If they were worried that they weren't on notice, they would have said something. Instead, they all filed briefs under the caption Plaintiff's Counsel, or a brief, under the caption Plaintiff's Counsel to respond to why there shouldn't be a sanction.
You are making a forfeiture argument in the context of due process. Do you have a case to support you?
It's forfeiture and it's harmless. There isn't anything they would have done differently that Don or Ann would have done differently. At the end of the day, does it matter if the sanction holds up against Karen? It doesn't matter at the end of the day. The $12,000 is collectible against somebody. And had it mattered, had the due process concern been a real issue during the district court, they would have allowed the district court to correct it. Instead, what they did was apparently sat on what they saw as procedural defect.
Is the answer to my question no?
Am I making a forfeiture argument in response to due process?
And whether you have a case that
I
you
do
can
not
point
have a
us
case.
to?
As I stand here, I don't have a case, Judge, that says that's fine for you all to do. There just isn't any question that the sanction here was proper. To your question on the form of the notice of appeal, the notice of appeal is clear on its face. And the notice of appeal on its face says that Karen Shaw and the law firm, Shaw Legal Services, were the appellants. That's repeated in 3 separate filings that the plaintiffs made in this court, including an affidavit from Ann Shaw in which she said, I am Ann Shaw and I represent the appellants, she says, Karen Shaw and Shaw Legal Services. There just isn't any question before the opening brief turns up who the appellant was. The appellant was Karen Shaw and Shaw Legal Services. As we discussed in our brief, the law firm is sort of a straw man here because the law firm didn't appear. The law firm is not, quote, quote, plaintiff's counsel under the operation of the local rules in the Northern District. Counsel is lawyers, not firms. In state court, the answer might have been different. The form of the notice of appeal is significant because they didn't appeal. Don Villar and Ann Shaw did not appeal and didn't recognize that they were in the middle of this until they filed their opening brief by sleight of hand. They add themselves as appellants. The entire thing is horribly unfortunate. And the district court exercised his authority to try and figure out what to do about it. What's the right answer? It's a deposition from the summer of 2017. 6 years later, we're still arguing about what happened. But most importantly, we're arguing about those 6 months from the date of that deposition through the end of that calendar year when the defendants were put through the trouble of hiring lawyers to deal with all of this. That's what the sanction is designed to address. To your point also, Judge, you had asked about the other sanctions that appear in the March 28th order. There is a sanction that removed Karen Shaw from the rest of the case. That is never dealt with in the briefs as being an improper sanction, as being an abuse of discretion, as being something that was not justified in these circumstances. That argument, whether it needed to be raised in a separate notice of appeal, I had not focused on that, but it's never argued here. That piece of the sanction is clearly proper. The second piece of the sanction, the district court referred the matter to the executive committee. That is never objected to. That's the second thing that he did. The third thing that he did was he directed plaintiff's counsel to address the amount of the fees. They did that. And in their briefing, they also argued about whether there should be any sanction at all. They got notice and an opportunity to be heard during the hearing and during the briefing on the amount of the sanctions. We noted in our brief that the issues about the amount of the sanction were brand new in the briefing compared to in the district court. That's not really dealt with in the reply brief. If your honors have any other questions, I'm happy to answer them. I believe this order should be affirmed and the case should finally get to its end. Thank you.
All right, thank you, Mr. Murphy. The case will be taken under advisement. Our next case has been submitted on the brief, so we'll move straight to case 4, United States versus Romeo Abrego, appeal number 23-1131. Mr. Beal, whenever you're ready.
May it please the court and counsel. Your honors, in this case, Romeo Abrego pleaded guilty to making 2 hand-to-hand sales from his home in Champaign, Illinois, of user quantities of methamphetamine, 7 grams and 13 grams, to a DEA confidential source on January 31st and February 7th, 2018. No one else was involved in these 2 sales. Mr. Abrego's source for those drugs is not in the record. The issue on appeal is whether those 2 sales are sufficiently similar to 151 grams of meth that were seized on March 29th from a man named James Rissler for that 151 grams to constitute relevant conduct to the 2 sales of the offense conduct. They in fact don't constitute, that is to say the 151 grams don't constitute relevant conduct because they don't meet the requirements of Sentencing Guideline 1B 1.3. The issue under the guidelines is whether the 151 grams were part of the same course of conduct or part of a common scheme as the offense conduct. But first of all, I just want to clarify that the fact that both sets of drugs came from Mr. Abrego is not determinative of the issue. This court has on numerous occasions stated, and I'm quoting from U.S. v. Ortiz, we have held that the mere fact that the defendant may have engaged in other drug transactions is not sufficient to justify treating those transactions as relevant conduct for sentencing purposes.
Mr. Beal, how is this case distinguishable from Mr. Singleton, from the Singleton case?
I don't know the answer to that. I'll explain why under the guidelines it's not it's not sufficient for the 151 grams. I know that the government cited Singleton. As I said, the guidelines provide that relevant conduct consists of all acts that were part of the same course of conduct or a common scheme or plan as the offense of conviction. And these, in this case, the 2 hand-to-hand transactions and the 151 grams are too dissimilar. And the best authority for that contention is U.S. v. Draheim, 958 F. 3rd, 651, a 2020 case from this court, where it says the district court needed to distinguish the nature of the two transactions. In one transaction, there was an individual sale of 2 grams of street meth in a city. In the other, there was a collaborative bulk order from the other side of the nation for nearly 50 grams of pure ice. A one-time order of a large amount of ice from a national distributor does not match up with a small street sale of meth to a local customer. And this is very similar. We're talking about 7 and 13 grams versus 151 grams. The cases are virtually indistinguishable. Likewise, Mr. Abrego's conduct in January is not part of a common scheme or plan with the March 29th. The February 7th and January 31st are simple one-off hand-to-hand sales from one person to another. By the time we get to March 29th, there's a much more complicated scheme going on that's very different. By that time, Mr. Abrego had moved to Texas after February 7th. He sent the drugs to Mr. Rissler in Illinois. Mr. Rissler, who was not involved in any way in the January 31st and February 7th, he's the one who makes the delivery of 4 ounces of the 6 ounces of the 151 grams is roughly 6 ounces. He's trying to deliver it to a cooperating individual for $4,500, and then the rest of the 6 ounces to somebody else. And obviously 151 grams is not a user quantity. So at this point, and in addition to that, at that point in time, Rissler was not only delivering for Mr. Abrego, he was selling his own drugs. He was a drug dealer on his own, and some of the drugs he got from Mr. Abrego he shared with an individual known as E, who was another drug dealer. So
do we know if Mr. Rissler was getting drugs from anybody other than Mr. Abrego during this period?
he had been selling, he began his relationship with Mr. Abrego in late December of 2017, and he had been selling drugs before that, so he had other sources. In terms of the specific drugs in this case, I'm not sure, but he definitely, in the record, it shows, had other sources of drugs. We don't, the 151 grams, we acknowledge, came from Mr. Abrego. So the point is that there's not, the two hand-to-hand transactions and the 151 are a very different course of conduct. They're, and don't, under the sentencing guidelines, don't meet the 1B1.3 criteria for a common scheme, because the fact that drugs came from Mr. Abrego is not sufficient.
Can you address the other elements that we would have to look at, not just the source of the drugs, but similarity, regularity, so forth?
Yes,
I know you pointed us to Draheim, but there are other cases, including, for example, Singleton, but others that you are perhaps...
Well, the application note to the guidelines says that they have to consider the degree of similarity, regularity, and the time interval as being criteria. And with respect to this, the degree of similarity is what Draheim addresses. The regularity, there were two. There was the January 31st and February 7th indistinguishable retail sales, and then this big sale or big transaction at the end of March. And those are the only two transactions that the judge found in the record. So that's all we have to go on are the offense of conviction and the 151 grams. And that, I would submit, doesn't constitute a regular course of conduct. They're two different transactions 2 months apart. In terms of timing, it's kind of a wash. I mean, it's not every week, but it's not a 2-year break. It's kind of an in-between break, so I don't think the temporal aspect is significant. I think it's kind of a wash as far as both parties go. But it's not two hand-to-hand sales and one major distribution are not a regular course of conduct. They're very different courses of conduct. And in terms of, that's the time, so we have similarity, regularity, and time interval. I don't think any of those support the finding of relevant conduct. The two incidents are too dissimilar, and they're not enough to create a pattern.
Are we barred from considering Riesler's testimony that over the course of the time they were working together, in total, he handled about 2 kilograms for Mr. Abrego?
Well, what I would say about that is that was contested. The only findings the judge made, he found the 151, and the government agreed with that, actually. This case, Mr. Abrego pled guilty relatively early on. Late in the game, the government came up with its relevant conduct. Now, I'm not accusing the government of doing anything improper by doing that late, but Mr. Abrego went nuts and moved twice to withdraw his plea agreement because he wanted to contest that relevant conduct. And there were a lot of, the defense attorney objected over a whole series of things, and the judge didn't make any findings. So this court shouldn't use these other transactions, which the judge did not make a finding on, to support the relevant conduct.
All right, thank you, Mr. Beal. Mr. Simpson.
Good morning, Your Honors. May it please the Court, I'm Scott Simpson on behalf of the United States. What we see here is Mr. Abrego's guidelines range was 188 to 235 months, and the district judge sentenced him at the bottom of that range to 188 months. Mr. Abrego was involved in an overall scheme to distribute methamphetamine in the Champaign area on his own and through other people. And all of the facts here indicate that Abrego's offenses of conviction, that is his sales of the methamphetamine to the informant, and his provision of 151 grams to Mr. Riesler are part of the same course of conduct, a common scheme or plan. I think it's important to point out that the 151 grams came from Mr. Abrego. He was transporting those drugs on behalf of Mr. Abrego. And to answer, I believe it was Judge Jackson Akumi's question earlier, during this period, December 2017 through March 2018, Mr. Riesler testified that all of the methamphetamine he distributed came from Mr. Abrego. And so that was the period during which Mr. Abrego or Riesler was working with Abrego, or the other way around. And Mr. Abrego's sales to the informant happened in the very middle of that period in January and February 2018. So I have to disagree with defense counsel that I believe defense counsel said the timing factor is a wash. I disagree with that. The sales, Mr. Abrego's sales to the informant happened in the middle of the period during which he was working with Mr. Riesler. Also happened in the same area. Mr. Riesler was working for Mr. Abrego in the Champaign area. That's also where the sales to the informant happened, in the Champaign area. Again, also this court's case laws looked at what the drugs are. Here, obviously, same drug involved, methamphetamine, in both the sales to the informant and in distributing through Mr. Riesler. Also, the amounts actually match. I mean, they aren't exactly the same, but Mr. Riesler was selling amounts of 3.5 grams to 56 grams on behalf of Mr. Abrego, and Mr. Abrego sold 7 grams and 14 grams to the informant. So we're talking about about the same quantities. So I don't think I mentioned earlier, obviously, the standard of review here is very deferential, clear error.
I don't think I follow your same quantities point. If we're comparing the two sales that Abrego was charged with, and then the 151 grams where nothing was effectuated with that amount. The police caught him with it, no sales. So can you help me there, please?
Your Honor, obviously, when someone's engaged in distributing methamphetamine, there are several steps in the process, and one of those steps, obviously, is transporting the drugs, and then they break them down into smaller quantities, obviously, to sell them. Mr. Rissler was transporting for Mr. Abrego 151 grams, and he was in that early in that process of transporting, and then later, presumably, he would have been distributing smaller quantities of that 151 grams. And so it was all a process of distribution that Mr. Abrego was directing. And again, part of the process of that was distributing or transporting larger quantities. And then Mr. Abrego was involved in selling to the informants. And Mr. Rissler, if we look at other facts of this case, other sales that Mr. Rissler himself made, they were in that same range of smaller quantities.
So your point is merely that one day the 151 was going to be broken down into smaller quantities, and you're comparing small quantities, small quantities. But correct me if I'm wrong, I didn't see anything in the record about the exact plans for that 151. So with prior sales, Rissler did a variety of things. He kept some for himself to use. He split some with Mr. Hill. He sold some at the direction of Abrego. But I didn't see anything in the record that established what the plans were for that 151 grams.
That's correct, Your Honor. We don't know exactly what the plan was, but I think as you look at the overall course of dealing that they were using, Mr. Rissler was selling amounts from 3.5 grams to 56 grams. Again, all of this on behalf of Mr. Abrego. So they were obviously engaged in that same conduct together, that same scheme or plan together. And that 151 grams was just part of that whole process of distributing, of transporting and distributing. So the
What's your
district court.
response to Mr. Bill when I asked about Rissler's testimony about the 2 kilograms? That in essence, the district court did not make findings about that, and so we can't look to that.
Your Honor, as you look at the sentencing transcript here, there were a lot of facts in the district court to deal with. There was, and as you said, Your Honor, Mr. Rissler testified that he dealt with a total of, he thought, about 2 kilograms on behalf of Mr. Abrego. You have that testimony. You have all of the other amounts that Mr. Rissler was selling on behalf of Mr. Abrego, user amounts. And you have the other seizures from Mr. Rissler. So there were a lot of, maybe I should say it this way, there are a lot of potential routes that the district court could have gone to determine the relevant conduct here. I think what the district court did was, number one, the 151 grams was a very clear. Mr. Rissler was caught with that amount, and so instead of being a 2 kilogram estimate, he was obviously caught with that 151 grams. And also, I think the district court, this is reflected in what the district court said in the sentencing transcript, that took the offense level to a certain amount. The threshold there was 150 grams. So since the court had that very clear fact of the seizure of 151 grams, and since it took him above the threshold of 150, I think that's why the court went to that. And the court is correct that there was no specific finding about the 2 kilograms. I think the court could well have used that 2 kilogram amount, but I think just to be very clear and to make sure that the record was very clear and that the court did not commit clear error, the court went with the 151 grams. I don't think we've discussed yet the role enhancement. The defense here also, in addition to the relevant conduct, the defense also challenged the role enhancement. I think the facts here easily support finding that Mr. Abrego was a leader or organizer, if not also a manager, a supervisor. Abrego had Mr. Rissler drive him around for drug transactions or anything that Abrego needed. I'm quoting here, paraphrasing in some places some of Mr. Rissler's testimony. Abrego directed Rissler in delivering drugs and collecting payment. He told Rissler where to go and how much money to collect. Rissler never knew who should receive drugs from Abrego, who should pay him, or how much of either of those things until Abrego told him. Once Abrego moved to Texas, he told Rissler where to take the drugs and what Rissler needed to sell that wasn't already meant for someone else. Each time Abrego sent methamphetamine to Rissler from Texas, Abrego directed Rissler to share a certain amount with E, whose full name is Emmanuel Hill, according to the record. And finally, Rissler never told Abrego how much methamphetamine to send to Illinois. Abrego just would tell him that it was on the way. And
Why
how
didn't the
much money.
government just charge Mr. Abrego or with the 151?
Your Honor, I actually don't know the answer to that, I'm afraid. I think it could well have been because the sales of the informant, you had the informant who could testify. That was would have been an easy thing to establish for conviction for the offense. And since they had and again, since I think the government recognized and ultimately the court recognized that the relevant conduct was, we believe, pretty clear, especially with the 151 grams. I think there was a recognition that.
But should the government be able to convict someone for 20 grams of methamphetamine, what they can prove, and then come through the back door with relevant conduct to increase their sentence?
Your Honor, that is exactly what the sentencing guidelines provide. They provide for relevant conduct, and the sentence can be based on that. And as this court has said in the past, I can't remember if I'm getting the phrase correctly, but this court has said that that is a powerful tool on the part of law enforcement, on the part of the prosecution. That is recognized, and again, that is what the sentencing guidelines provide, and to that extent, it is considered fair. So we would urge the court to affirm.
All right, thank you, Mr. Simpson. And the case will be taken under advisement. Mr. Beal, you were, yes. Yes, sure, you can. You were appointed in this case. So you come on, sure.
With respect to the amount 151, that's approximately 6 ounces. Paragraph 19 of the pre-sentence report states that 4 ounces were going to a government cooperator for $4,500, and the rest were going somewhere else. So that's in the pre-sentence report of the case. And the other, I would just sort of reiterate that Mr. Abrego challenged the credibility of the informant, Rissler, and twice moved to revoke his plea, take back his plea agreement so he could challenge at trial under a beyond a reasonable doubt standard the relevant conduct, and that those motions were denied. But there was a challenge to the beyond the 151, the amounts beyond the 151 grams were challenged in the sentencing hearing, and Mr. Abrego wanted to challenge them at trial.
Okay, thank you, Mr. Beal, and thank you for accepting the court's appointment in this case. The case will be taken under advisement, and our last case of the day is Cornice and Rose International LLC versus Acuity, appeal number 23-1131. Mr. Smick?
Thank you, Your Honor, members of the court, counsel, and may it please the court. I would like to reserve 3 minutes for rebuttal, if I could, please.
That's fine, you just have to watch the clock.
Thank you, Your Honor. We are here on an insurance coverage dispute. As the Federal Circuit Court of Appeals, sitting in Illinois, We get we get more than our share of coverage disputes here. And as a result, there is quite a body of case law here in Illinois on various issues. But we come before the court today with a set of unique facts. We have an architect and his firm being sued in first the Northern District of Iowa and now in Iowa State Court with allegations in the complaint generally of a design defect. But when the underlying complaint gets into the specifics, it alleges a laundry list of construction defects. Further making this case unique is the fact that in most cases, architects will carry malpractice insurance, for lack of a better word, errors and omissions coverage. And in turn, the commercial general liability carrier, like the appellee in this case, Acuity, will exclude coverage for professional services. We don't have that here.
I know you don't have the exclusion, but do you also not have the malpractice coverage on the other side?
There is no malpractice coverage in this case. My clients did not maintain their malpractice insurance. So they have come to their commercial general liability carrier, Acuity, saying, please cover us. Please cover us under the insuring agreement that says we will pay all sums that the insured becomes legally obligated to pay because of property damage that is caused by an occurrence. The claims are submitted to Acuity. Acuity responds, no. This is not covered under our commercial general liability, CGL policies, because in Illinois, one's own work product, faulty workmanship, is not an occurrence. The difficulty with Acuity's argument is the case law that they cite for that proposition deals with contractors, the builders themselves.
Well, you did start with the idea that this is a unique set of facts. But is it? We do have Illinois case law that deals with architecture firms like Cornish and Rose. Take, for example, Pekin Insurance versus Richard Marker Associates, okay? There we've got an architectural firm, and they were sued for breach of their architectural services agreement, but also failure to design proper location, installation of plumbing pipes, failure to insulate exterior facing areas, breach of the construction contract, et cetera, et cetera, et cetera. And they went to their insurer, just like your clients have done. And, what the Illinois Court of Appeals did was look to these the commercial general liability contract and find that, this is faulty workmanship, a faulty workmanship issue. There's got to be damage to something, other than just a general an allegation that the building itself was defective. So, they're damage to furniture. So where's the uniqueness if we have already sources like Pekin that tell us what to do, even if an architecture firm is involved?
The uniqueness of these facts, Your Honor, is that we have an insured being sued again under a very general allegation of architectural malpractice, a design defect, if you will. But then the complaint goes on to allege all sorts of construction defects, walls out of plumb, improper flashing, things of that nature. And somehow, some way, this plaintiff is going to try and connect those dots between Cornish and Rose's design and the actual construction of the building. They claim the building was incomplete.
Just to put a finer point on it, the counterclaim is the services that you were to provide were designing the building in Iowa and overseeing its construction.
They do claim some oversight of the construction, but really not, because they attach, and the underlying complaint actually alleges a breach of contract, especially in the Iowa State court case. They allege a breach of contract, and they attach that contract.
And so if you agree that it's there designing the building as well as overseeing its construction, how can design and construction defects fall outside the scope?
They are, well, that was my point, Your Honor. In the contract that my client signed with the developer, that eventually went belly up, unfortunately, but that said that Cornice and Rose has no responsibility for construction. That is in the contract document that is cited in our briefing.
And doesn't that same contract, though, give you the responsibility of overseeing construction?
It does, well, in this case, it specifically excludes it. It says you are to design the building, you are to provide plans, but you are supposed to, provide completion documents. There are some administrative duties in the contract, but we submit to this court that when one reads the provisions of the actual contract, it says you, Cornice and Rose, have no responsibility when it comes to the construction. But
when it comes to the construction, does the contract say that you are to oversee the construction?
It does not.
All right.
So in the 30 seconds I have left before my rebuttal time kicks in, I would like to mention that really the one case we have that approaches analogous facts is this court's 1997 ruling in Prisco Sturm Architects. There, this court did a proper coverage analysis.
That case had a subjective clause, though, that this one doesn't.
It does, but this court, as the district court did below, undertook a proper coverage analysis, and it began with the definition of an occurrence, and it found that because the architect could not reasonably foresee the construction defects that ultimately popped up, the definition of occurrence and property damage were satisfied. So with my 2.5 minutes of rebuttal time, if I may stand down, and I'll make my final request to the court.
I do need to follow up on the determination regarding overseeing the construction. And so the contract at item 3, and that's found in the docket 1-8, it says that Cornice is to evaluate the project regularly to become familiar with the progress and quality of the work completed, and to endeavor to guard the owner against the defects and deficiencies in the work. And so that language is where I'm pulling the question, were you obligated to oversee its construction?
Again, we submit that the contract does not require oversight, because it does say the architect shall not have control over
I want to confirm
charge.
that language that I just pulled, that does come from from the contract.
I will check that as counsel makes his argument.
All right, if you will check, it's docket 1-8, paragraph 3 of the contract. It's also, I believe, included in the counterclaim.
Okay. Thank you, Your Honor.
Thank you, Mr. Schmick. Mr. Postal.
Thank you, Your Honor. May it please the court, Joseph Postel for Acuity Insurance. I think, Judge Jackson, you came up with the key here. There is nothing unique about this case. There is nothing unique about an architect seeking coverage under CGL policy for construction defects. Granted, the body of case law on insurance coverage for defective construction usually involves a contractor, but not always. As Judge Jackson pointed out, the Pekin versus Richard Marker case involved an architect. The Viking case, which was discussed at some length in the briefs, indicated that it involved a construction manager, which is also not actively involved in not directly involved in the construction. So there's nothing about the role of an architect that sort of exempts Cornice and Rose from the ordinary principles of determining insurance coverage. Their policy still provides what all the policies in those other cases provided, and that is you're covered for property damage, liability for property damage caused by an occurrence.
And is that where the disagreement is, as to what context, whether or not this qualified as an occurrence or if there was property damage?
Yes, that is where that is the ground on which the dispute is being conducted. Is there an occurrence, and what did it cause property damage? So again, the fact that that you have an architect here and that there's no professional services exclusion in the policy, that doesn't change the fact that you have to have property damage caused by an occurrence. So as far as occurrence is concerned, they rely exclusively on this Prisco Sereno Sturm Architects case, which applied the wrong standard. The Viking court declined to follow Prisco for two reasons, or for one reason, and other courts have given an additional reason. So the first reason is
Excuse me, sir.
Yes.
I want to talk about that. You are correct about Viking, but Prisco is our circuit law. You know, it's obviously a case we might look to in resolving this dispute. Do we need to do something about that to fine for you?
Not necessarily. I think you can recognize that in the Nautilus case, the Seventh Circuit applied a different standard for determining occurrence than the court in Prisco did.
I'm not sure about that, though. Nautilus applied an objective test. Prisco applied a subjective test. In the contract in Prisco, there was a subjective element intended. In Nautilus, there was not. And here, there is not. Why does that not, by itself, distinguish Prisco?
Well, I don't think the Nautilus court even mentioned what you just mentioned, Judge. I think the debate is over whether, or the different standards are. On the one hand, the Prisco standard is, the court said, the complaint doesn't allege that Prisco intended or expected for the school to have to pay for work that was done improperly. That was, and because there was no allegation that they intended or expected it, therefore it's an occurrence.
Right, and we don't have that here, though. There's no requirement in this contract regarding intended or expected. That's subjective. Right?
Well, I understand, but that was the language, that was the standard that the court applied to determine whether there's an occurrence.
In Prisco.
Correct.
Doesn't that distinguish Prisco from this case?
Well, arguably, yes, because this case involves the definition of occurrence as an accident, including prolonged or repeated exposure to substantially similar conditions. So
Period.
So there is no, yes, you're right. So the occurrence definition formerly had those additional words, neither expected nor intended, from the standpoint of the insured. The exclusion no longer has those words. It's just a question of whether it's accidental. And to determine whether it's accidental, the test is the one employed by the Nautilus court, by the Viking court, by the Stone Ridge court, by virtually every court in the last 20 years, and that is whether the damage was the natural and ordinary consequence of the defectively performed work. So that's why Prisco does not control this case. What does control this case are the Illinois Appellate Court cases, which the Nautilus court certainly seemed to adopt in its holding. The Nautilus court, for example, let me check my notes. The Nautilus court cited Stone Ridge and Viking, the Illinois Appellate Court cases, in adopting the rule that the natural and ordinary consequences of an act do not constitute an accident. And damages that are the natural and ordinary consequence of faulty workmanship do not constitute an occurrence or an accident. Now, I understand that
I think we would have to do something with national decorating as well.
yes. So national decorating is relevant to a separate issue, and that is this sort of little exception that's been carved out to the Illinois rule that you don't have an occurrence if the defect involves the building under construction. National Decorating recognized an exception where an insured who's responsible only for a part of the construction, in National Decorating it was a window sealing contractor, subcontractor, does its work defectively, and as a result, other parts of the construction, not within its scope of work, get damaged. So the court found that's an occurrence. You don't have that here. Cornice and Rose is not responsible only for a portion of the construction. They're responsible for the entire project. Again, yes, they didn't directly do the construction work, but neither does a general contractor in most cases. They simply sub out all the work and they just superintend it. So the idea that Cornice and Rose, or architects in general, are in a completely different position here is just, I reject that, and I ask the court to reject it. The case law on occurrence, property damage, and the difference between economic loss and damage to the property of others, this is well settled in Illinois law. There's no reason it shouldn't control this case, and for that reason, we ask the court to affirm the district court's judgment.
All right, thank you, Mr.
Thank you,
Postel.
Your Honor.
Mr. Smick, we'll give you your 2.5 minutes in rebuttal.
Thank you, Your Honor. So with the court's permission, I'd like to address Judge Pryor's question that we left off with. And indeed, the contract does say that Cornice and Rose was to become familiar with the progress and quality of the portion of the work completed to endeavor to guard the owner against defects and deficiencies in the work. But then the contract goes on to say that Cornice and Rose is not responsible for the construction manager's failure to perform the work in accordance with the requirements of the contract documents. One of the allegations we have in the underlying counterclaim and in the underlying complaint, Your Honors, is that, quite simply, the project was never finished. So that is just one example of the general contractor, who is, by the way, a co-defendant in the Iowa State Court case, Hildreth and Company, not completing their work, not performing under their contract. But allow me to bring the court back to a basic premise of insurance law in the little time I have left. In Illinois, and in most cases, and in most states, the duty to defend is broader than the duty to indemnify. We've heard that so many times in these cases. All inferences with respect to the duty to defend are to be drawn in favor of the insured, not the insurer. And even in Prisco, this court began its ruling by saying, torn between the desire to use common forms which ought to lead to consistent results and the need to tailor coverage to particular situations, the insurance industry often ends up with policies that are, to put it charitably, convoluted. Those of us who practice in this area know construction defect, professional liability, and commercial general liability policy language, it's like a square peg in a round hole. We have to make all sorts of arguments. Courts have struggled with this language. Illinois has come up with the natural and ordinary consequences approach to property damage caused by an occurrence. And I will submit to the court in closing that Prisco acknowledges that rule. Prisco cited the Illinois case of Hydra Corporation, where indeed the natural and ordinary consequences rule was addressed. So we submit to this court that Prisco, among the very few cases, and this court's binding precedent, should have required the district court to grant Cornice and Rose's motion for judgment on the pleadings and deny Acuity's motion for judgment on the pleadings. We ask for a reversal on that basis. Thank you, Your Honors.
Great. Thank you, counsel, and the court will stand in recess.